So I'm going to talk about how we all got here as being planning boards. So first, according to RSA 673-2, the planning board is formed when the legislative body, in the form of a warrant article, is approved. And that legislative body, as we all know, is either through the town meeting, town council, or city council form of government. So once you've created your planning board, your first order of business is to elect your officers and the process of how you elect those officers, when you elect them, and who those officers would be, which is usually the chair, the vice chair, and the secretary. After you've done that, you are required to adopt your rules of procedure. And that's according to RSA 676-1. Once the officers and the bylaws are in place, the next order of business is the adoption of the master plan. That's according to 674-2. And once the master plan has been adopted, and you can begin working on the zoning ordinance and or your site or subdivision regulations. So it's kind of the natural chronological order of how you start to work on the things that you're responsible for. And after the master plan and the subdivision regulations have been adopted, the municipality can choose to adopt the site plan application process. And this would be done in the same manner as the subdivision and zoning ordinance process, which would be through the legislative body through an amendment. And although not really part of the discussion today, I'm just kind of showing you on the flow chart of the other things that are necessary for the planning board to utilize by having a zoning ordinance in place. And in order to enact a CIP and to implement impact fees, you need to have the master plan and the zoning ordinance in place. Also, just as a reminder here, in order for you, for a municipality to adopt and utilize site plan regulations and process, you have to have the zoning ordinance and subdivision regulations in place. And so now that you're on a planning board and you have some things under your belt already, what else are you responsible for? Again, you are responsible for the creation, amending, and implementation of the master plan, subdivision, and site plan regulations. You are also the gatekeeper for the zoning ordinance and zoning amendments, which means that you are responsible for the proposal of amendments, which includes accepting petition zoning amendments. The planning board makes recommendations whether or not to either support or not support amendments, and you're responsible for holding the public hearings for public input process. So you're in charge of the master plan, you're in charge of the subdivision regulations. If you so choose, you're in charge of the site plan regulations. Other things you're in charge of are the excavation regulations. Usually in the majority of the communities in New Hampshire, the planning board is the regulator of excavation regulations, but there are a few communities where the selectmen or the zoning board of adjustment are the regulator of the excavation regulations and the process. And I've noted just a few more in case you weren't all aware of what you're in charge of. Capital improvements, innovative land use controls, developments on class 6 or private roads. Again, those are all the other RSA required obligations that the planning board has. So as I just spoke a little bit about, the planning board has to adopt rules of procedure as part of their first order of business. So according to RSA 676-1, says in the law that requires the board to adopt rules of procedure concerning the method of conducting business. So that should spell out the rules that the board has to follow, rules how they operate, and those rules also should be made available to the public. I've included a link here to our handbook, the Planning Board in New Hampshire. It's on our website. If you go to Appendix C, that is kind of a template and kind of gives you some good groundwork to start looking at to adopt and to amend your own rules of procedure. So you're in charge of reviewing formal applications. So a formal application, according to 676-4, that means that's how the board has to have their procedures and their mandates for how they operate with their applications. 676-4-1B says the planning board shall specify by regulation what constitutes a completed application sufficient to invoke jurisdiction to obtain approval. And a completed application means that sufficient information is included or submitted to allow the board to proceed with consideration to make an informed decision. So what does all that mean? So that means the planning board, you as the planning board, you are the ones who get to decide what type of information you require in an application that you are asked to review and approve and consider. So the way to do that, the best way to do that, I would say, is through checklists. And checklists are how the board can specify by regulations what constitutes a complete application. So the board should adopt checklists as part of their subdivision and site plan regulations. Checklists should include types of plans, studies, types of the design of the plan, information required on the plan, all those types of things. Again, keeping in mind that any information that you deem necessary to be submitted in order for you to make an informed decision is what should be translated to your checklist. So before an application in front of you can be considered complete for acceptance, the planning board staff or the board's designee should review the application to see if it's initially complete for the board to consider. So this would include a review of the submitted information, just to verify that everything has been included. The checklists, fees, the plans are right, you have enough copies, reports, all of those things is just an initial kind of an administrative review to make sure that that application has enough information that you could then further to the board. So I realize there's planning boards without staff support. Maybe the secretary of the planning board could be the one that is in charge of just doing that initial intake, that initial process check to make sure that the submission contains all of the required information prior to the meeting. If that is not feasible to do that, then the board can do that at a public meeting where they're just simply saying yes or no, this application has the required information. As an option, the board can consider maybe without staff, this could be a consideration, is that you could conduct a completeness review as part of the conceptual consultation process. So the applicant would come in with their application, with their preliminary information and engage in a conversation with the board to learn what the board's requirements would be in order to have a complete application. And then, once that it's been deemed that enough information has been submitted, the application is accepted as complete at a public hearing with notice to the abutters and the public. And again, I've included a link on the slides for your convenience for you to go to our handbook, because we have a checklist template there, which again could be your jumping off point for what you would like to have in your own regulations. So site plan regulations. The statutes specify the administrative functions and procedures of site plan regulations must include the purpose, procedures, standards, what makes a completed application, checklists, as well as enforcement and administrative policies. They may also include things like traffic, parking, utility location, landscaping, building location. Again, all those things that what they may include or what the board can include to make themselves have enough information to make a informed decision. Then site plan regulations are used to ensure that permitted uses by the zoning ordinance are constructed and operated in such a way that they fit into the area which they're being constructed without causing drainage, traffic, lighting, noise, or similar problems. They apply to commercial and industrial development, multifamily buildings, and changes of use in businesses. So if you choose to adopt site plan regulations, I mean, I'm kind of a recommendation that you do because it does have the planning board the ability to review and approve commercial uses in your town. And they should reflect some aspects of the master plan in the zoning ordinance, meaning that, you know, if you're going to have your site plan review regulations, you should be cross-referencing those with your zoning ordinance to see where the uses are allowed, and with your master plan to see where the community has spoken up to indicate where they would like uses and what types of uses in town. So there's a few little different types of site plans. So the local legislative body of a municipality, again, which is town meeting, city council, town council form of government, may by ordinance or resolution authorize the planning board to delegate its site plan review powers and duties regarding minor site plans to a committee of qualified personnel for whom are chosen by the planning board. These members can be members from the municipal departments of public works, engineering, police, sewer, fire, water, any of those departments that the planning board seems would be beneficial for the minor site plan review process. And we also generally call this the minor site plan review committee. So if you do move forward and choose to adopt the minor site plan review process, the planning board shall adopt or amend its own site plan regulations for what constitutes the application type and process, thresholds, and what kinds of site plans can be reviewed by the minor site plan review authority committee. So as an example, maybe simple changes of use applications or a new building under 5,000 square feet or paving under a certain amount, those types of things, while they're still warranted to have town review and approval and enforcement, maybe they're not as big to go to the planning board for a full-blown planning board application. The minor site plan review committee can also be used as part of the application process, where if you do have a large application coming through the planning board process, having a stop at the minor site plan review committee for input from all of the departments is helpful to the applicant. It's also helpful to the planning board, kind of helps prepare the applicant in a little bit better of a fashion for when they get to the planning board for what should be expected for a large major site plan. And all of the provisions of RSA 676-4 shall apply when dealing with the special site review committee. So subdivision regulations. What does a subdivision mean? The division of a lot, tract, or parcel of land into 2 or more lots, plats, sites, or other divisions of land for the purpose, whether immediate or future, of sale, rent, lease, condominium conveyance, or building developments. It includes the re-subdivision of land when appropriate. So subdivision regulations must be consistent with the goals of the master plan. Like for the site plan regulations, subdivision regulations need to outline the requirements for a completed application, the checklists, the fees, schedule, what their thresholds are for major and minor subdivisions, and as well as comply with what's outlined in RSA 674-36. And so regardless of whether a municipality has adopted a zoning ordinance, the legislative body may authorize the planning board to regulate the subdivision of land according to RSA 674-35. And so subdivision controls are based on the premise that a new subdivision is not separate from the community, but an integral part of the whole community, in which it effectively connects the municipality through a pattern of streets, sewer, water lines, other municipal facilities that provide essential services, and vehicular and emergency access is crucial. So those are the kinds of things that we're talking about when we use the term scattered and premature development. Okay, you hear that maybe kind of thrown around a lot, but when you want to think about, well, what does scattered and premature development means? It means that those are the uses that those issues of Where is it for community facilities? How is it located to our street program? How is this subdivision going to be integrated into the community? And so those are the issues that the planning board should be considering when reviewing a subdivision and a site plan, to see whether or not scattered and premature development is being proposed. And just as a practice pointer here, as a reminder, the adoption and the amendment of the subdivision and site plan regulations for the planning board can be done at any time during the year. Those types of regulations and other regulations that are under your purview, they do not have to go to town meeting. They do have to follow the normal notice to the public, where 10 days in advance, final decision and things are made at a public hearing, but they do not have to go to town meeting. So you have leeway to amend your regulations a little bit more frequently, keep them more up to date. So again, just so as a little reminder about your subdivision and site plan regulations, you should be adopting checklists and applications as part of the regulations. Amendments to the site plan and subdivision regulations, again, can be done at any time. The final adoption of any amendments need to be done at a public hearing. You can certainly work on your amendments as advertised on an agenda on a work session, but the final adoption of any amendments and any changes to any regulations, also including your rules of procedure, need to be done at a public hearing. And again, that notice to the public for those regulation amendments are done the same way through a formal application process or your zoning amendment process, which is 10 days in advance. So those does it for my bit of the presentation for an introduction. I am now going to turn it over to Ben Frost, and he's going to talk about procedures and guidance as a planning board member.
Morning, Stephanie. It is just such a pleasure to be with you today, and Ross. I honestly can think of no better way to spend a Saturday morning than talking with a whole pile of friends about planning boards and subdivisions and site plans. At least it beats being outside being desanguinated by black flies.
Yeah, it's a good time for us planning geeks, right, Ben? We thank you and Ross again for giving up your Saturdays to spend some time with us. So thank you.
I'd say Ross in particular, he's giving up his entire morning.
I know, Ross is doing double duty, so he gets the extra special gold star today. Thank you.
So what I want to do is talk a little bit about the perspective of site plan and subdivision process at the planning board level from the perspective of a small town. As Stephanie said, I'm the chairman of the Warner Planning Board. I've been on the planning board in Warner for about 10 years, been chairman for the past 6 years. And it's a labor of love, that's for sure. And I do enjoy it. In part because I'm giving something to my town, and I feel good about the work that we do on the Warner Planning Board, working with applicants, working with abutters, working with townspeople to resolve some of these difficult issues that we face, even in small towns. I'll be particularly interested to hear Ross's perspective from a large town. So Warner is a town of about 2,800 people, no professional planning staff. So the planning board is really doing things pretty much on its own. We do have an administrative assistant who's really terrific and just super with customer service. But from a professional planning standpoint, we rely on the Central New Hampshire Regional Planning Commission to provide some circuit rider services. So we have a contract with them to help us with some of the more difficult applications. So the process that we use in Warner is probably going to be a bit different than what Ross might describe as is the process of his planning board in Salem. And that is, we may be a little less formal in how we handle things. The planning board is doing the bulk of the work. And in a larger town like Salem, that's simply not practical because Ross's planning board is handling a whole lot of things, very large scale development, a lot of stuff on their agenda every time they meet. on occasion, we'll have a subdivision application. On occasion, we'll have a site plan application. A lot of these things we won't even send out for external review by the Regional Planning Commission because they're so small and so simple, like a 2-lot subdivision that doesn't have anything notable associated with it other than drawing a new boundary line. In my perspective, it doesn't really need external review. But something more complex, like the establishment of a new drive-through Dunkin' Donuts at Exit 9, you can check it out yourselves, that has an underground stormwater retention structure that straddles 2 lots. That is a lot more complex from an engineering perspective than my board could handle. I'm not an engineer, so we did send that out for engineering review. And I'll talk about third-party review as we move along. Stephanie, I'm going to start at the beginning here. Rules of procedure. Stephanie did indicate that pursuant to RSA 676(1), rules of procedure, you have to have them. You cannot operate without them. Well, you can operate, but you can't operate legally without rules of procedure. My advice here is don't use Robert's rules. Robert's rules are intended for large parliamentary bodies. And they have very complex processes designed out of necessity to handle how large parliamentary bodies conduct their operations. So, for example, the New Hampshire legislature, the House of Representatives, body of 400, uses Mason's rules of parliamentary procedure, which is similar in many ways to Robert's rules. It has all kinds of different things, the precedent of motions and all those different things. You don't need them. You don't need them. What you do need to do is to take a look at the model that the Office of Planning and Development has in its Planning Board Handbook. This is Appendix C. It's really good. That's a good place to start. If you don't know where your rules of procedure are, find them, read them. If you do have them, take a look at them and make sure that you're following them, generally speaking. I'd say follow them. Be consistent in how you follow your rules of procedure. They're there for a reason. They're there to give instructions to the applicants. This is how the planning board is conducting its business. To the public, this is where we fit into this process, and to yourselves, the planning board members. How do you conduct your meetings? Things that you want to include in there is how to conduct the meeting. What's the process? What's the order of business? Also, by statute, you should be addressing how your alternate members are participating in the meeting. And different boards do things different ways. So some say the alternates can't sit at the table with the regular members. They have to sit in the audience and observe. They can't speak, except, I suppose, as a member of the public. Generally speaking, I don't think that that's necessary or even beneficial, because sitting at the table with the regular members, even if they're not voting on something, is a good way for alternate members to get the feel, get the experience of what it means to serve on a planning board. So in generally speaking, the way I look at how alternate members can, and this should be in your rules of procedure, can participate in a meeting is when there's a public hearing, when there's interaction with an applicant. The alternates can ask questions. They can make their views known. They can provide information. But they can't make motions. They can't second motions. And once a motion has been made and seconded, the alternates should be quiet. The deliberation on motions is for those people who will be voting on the motions. The only time an alternate should be participating is when they have been seated in place of a regular member who's absent or has a conflict of interest and has had to recuse themselves. In that case, then they have the full power of a regular member and they should be participating as a regular member. Your rules of procedure should also address how you're conducting joint hearings. So whenever there's a joint hearing, and this is fairly rare that this happens, but sometimes it does, say a planning board and a ZBA are meeting together because they need to hear the same information about a particular application that they're both dealing with. In that case, by law, the planning board chair chairs the joint hearing. And your rules of procedure should identify how you proceed with this. And again, the OPD model rules of procedure have very good instructions on that. Also, and this is something that I started thinking about, probably 25 years ago, is the notion of reconsideration of decisions. It's actually a lot longer. It was in the late 80s. I was the town planner in Kittery, Maine, and it was a late planning board meeting, and my planning board made a decision that they came to regret almost immediately. The next morning, they woke up and said, "What have we done?" And they had denied an application, and for the wrong reasons. And it had been a late night, and they were just not themselves. So we figured out a way for them to reconsider. And this is actually one instance where I did look at Robert's rules, notwithstanding what I said earlier, for a pattern of how to deal with a reconsideration. And generally speaking, someone who has voted in the majority can move to reconsider that motion. So if you had say a 4-3 vote, one of the four who voted in either to approve the application or deny the application, whoever was in the majority on the motion, has the capacity to move to reconsider that decision, and then so that has to be seconded, and that revives the underlying motion. The process of reconsideration should be part of your rules of procedure. And reconsideration is, generally speaking, a good idea as long as it is done within the statutory appeals period of 30 days. Once you've made a decision, the applicant or other interested parties have 30 days in which to sue you in Superior Court. As long as you're doing that reconsideration within that statutory appeals period, you should be okay. And in fact, a judge who is reviewing a decision would appreciate your effort to reconsider what you concluded was an erroneous decision. They always want to see local boards correcting their own errors. So that's a good thing. A couple other things that I haven't listed here. How do you deal with developments of regional impact? This should be in your rules of procedure, and I'm not sure if the OPD model has that in it. My board, though, the Warner Planning Board, is dealing with this right now. We're revising our rules of procedure to incorporate how we address developments of regional impact. And this is an important thing for you to do, whether you're dealing with it in your rules of procedure or not. By law, anytime you as a local land use board are considering an issue, an application, subdivision, site plan, whatever it is, someone has applied to you for permission to do something, you have to ask the threshold question, is this or is this not a development that has the potential for regional impact? If you don't ask that question and answer it, you face the potential of making an invalid decision because a reviewing court might say, you didn't determine whether you have regional impact. Therefore, you didn't have jurisdiction to even consider the application. I've seen this happen where a ZBA never asked the question, got to court, and the judge said, well, you never asked if this had regional impact, asking yourselves to answer that question. And so the judge said, therefore, I'm throwing out your decision, go back and do it again. Beyond that, and this is not something you necessarily include in your rules of procedure, and I know Steve Buckley mentioned this last weekend when he was talking about planning board process. There's this thing called the Riggins rules. Fred Riggins was the chairman of the City of Phoenix Planning Commission in the late 60s and early 70s, a long time ago. And he wrote up these Riggins rules. And these are rules of conduct, how you comport yourselves as board members. They're dated, they're not politically correct, but they have a lot of good substance to them. And it gets to how you comport yourself as a member of a board and how you treat the people who are appearing before you. I encourage you to Google the Riggins rules and read through them and take from them what you might. Now, Stephanie talked about the checklists and that should be in your subdivision and site plan regulations. These are really important because these serve as instructions for applicants, but they're also instructions for you, the board members. What should you be looking for in an application? So you should have a checklist that an applicant is filling out, and then that you review to determine, well, is all the information there that we need? It's instructions. You should also be identifying in your checklist what things an applicant is seeking a waiver from. So these may be requirements in your regulations for one thing or another, and the applicant says, yes, I've supplied this and here it is, or no, I don't think this is necessary, therefore I am requesting in writing a waiver from this particular standard. Some of these waiver requests you'll deal with at the outset, and some of them you might want to hold off on and decide later because you may not be in the position of saying yes or no, we do or don't need this. That decision may come later. So there are some, as I say, there are some threshold waiver questions, and then there are some that you'll hold for later. Fundamentally, though, when you're going through the checklist, you are preparing yourself for this question. Is the application sufficiently complete? And this is the language that Stephanie used earlier, sufficiently complete for the board to accept the application for consideration. Is there enough information there for you to start your process? And it doesn't mean that everything has to be there at the outset, but is there enough information for you to begin your review? If there is, then you are legally obliged to accept that application and start your review of it. If you say, well, no, there's not enough here, and we're going to send you back. Okay, you can do that if there truly is insufficient information for you to consider an application, like engineering is absent. You're presented with a pencil sketch for a 20-lot subdivision. No, that's not okay. You would say that is insufficient. We need the engineered plans. We need the surveyed property boundaries. But if the answer is yes, then you must accept that application. If the answer is no, you have to identify in writing the things that are missing. So next time around, when an applicant is coming to you, say with okay, here are the things that you listed last time, and we presented them, then you should accept that application. You should not be saying, yeah, you got this list of things that we said last time we're missing, but we've also identified these other things, these other half dozen things that are missing. No, you should be giving them in one shot all of the things that are missing that they would need to present to you in order for you to say, yes, this is sufficiently complete for us to start the process. Failure to do that will potentially wind you up in the court and on the wrong side of a decision. This was the case back in, I think, 2002. The case is Rallis versus the town of Hampton, and the Hampton Planning Board was, in essence, whether intentionally or not, was delaying the acceptance of an application, and the court said, no, you can't do that. There was sufficient information there for you to accept the application. You should have accepted it, and therefore get to work on this application. Now, waivers. We've talked a little bit about waivers. Waivers are really important because you have these standards in your subdivision and site plan regulations, but they're not specific to a parcel of land or to a development idea. So not all of the standards you have may be applicable in any given case. As Stephanie noted, subdivision regulations may include waiver provisions. Site plan regulations, this is by statute, must include waiver provisions, but the statutory standards for the two are the same. And you see these two different tests here, and a waiver has to meet one of these two tests. That is, the planning board, in deciding to grant a waiver, has to find either that strict conformity would pose an unnecessary hardship to the applicant, and granting the waiver wouldn't be contrary to the spirit and intent of the regulations. Okay, let's take a look at this. This is the standard that's been in the subdivision regulation enabling statute for a long time, probably since it was first created or at least recodified back in 1983. And that question of hardship, it's not the same thing that a zoning board of adjustment considers when they're looking at the hardship criterion in whether the question of whether to grant a variance to zoning. It's a different sort of standard. It can be personal to the applicant. It can involve financial hardship. So I'll give you an example. Let's say you've got a 2-lot subdivision and the tract of land is 500 acres and the applicant, the property owner, wants to subdivide off 2 acres. And you have as a requirement in your subdivision regulations a full boundary survey. That is a requirement. Well, you've got this 2-acre tract that's on your town road and it's just in the corner of the 500-acre tract. Do you really need the full perimeter survey of the 500 acres in order to achieve this, the subdivision of the 2-acre lot? Probably not. That would be potentially prohibitively expensive for the property owner, the applicant, to do. So you might say, yeah, we don't need to see the full boundary survey. Just do the survey of the 2-acre lot and some kind of legs of the boundary of the 500-acre lot. So that's one where there'd be hardship that's a financial hardship to the applicant. The second prong here, the second test, not a prong, because they are alternatives, is a more recent one. And this comes from a Supreme Court case, Osier versus the town of, I can never remember, it's either Stratford on the seacoast or Stratford up north, Osier, A-U-G-E-R, in 2007, where the town, the planning board, excuse me, granted waivers for a subdivision because, not because there was hardship, but because it resulted in what they viewed as a better plan. The abutter disagreed and sued, and the Supreme Court said, well, that might be correct from the planning board's perspective, but the planning board never found that there was hardship. So these waivers should not have been granted, or they were not properly documented. And I believe that was sent back to the planning board for reconsideration on remand. So following that, in 2007 and 2008, the legislature adopted this provision, giving planning boards the ability to grant waivers in the absence of hardship, but where it would, in effect, result in a better plan. The specific circumstances relative to the plan, the conditions of the land, but that will properly carry out the spirit and intent of the regulations. Waivers should be submitted to you in writing, and each waiver should be addressed by you, the planning board, separately. That is a motion to grant a waiver, and the reasons for granting the waiver should be recorded in your minutes. That is a legal requirement. All right, next, let's move on to the completeness of the application. Let's say your answer is no. It's not sufficiently complete for us to begin consideration. So you reject the application as incomplete. And one of the reasons can be the failure of the applicant to pay the fees. Well, you didn't pay the fees. We're not going to hear your application. It's incomplete. And go back and try again. Come back with a check next time. But you have to state in writing the things that we're missing. This is what I was talking about before. You can't do this iterative thing. Oh, you missed these half dozen things. They come back with a half dozen things. Oh, you missed these other 2 things. No. One time, list all of the things that will be necessary for the applicant to present to you to form a complete application. If the application is incomplete, you never get to the public hearing process, because the public hearing is held only after you have accepted the application as being sufficiently complete for you to consider it. What happens, though, if you get someone who just won't give you the right information? They keep coming back to you. You can keep rejecting it as incomplete. But once they present the information that you're asking for, you should accept it as complete. But um, what are the differences between complete or changes to a plan that allow you to accept it? Sometimes the plan doesn't change. Sometimes the application doesn't change. Sometimes the circumstances change, like the law underlying it. So there was a change to the law of variances. It doesn't affect planning boards, but the principle remains the same. If the law changes that allows a project to proceed, that is a material change to the application, and you might be compelled to accept that application, even though the application itself was the same as something that you had previously rejected. So you look for significant changes that are in the plan, the materials that are submitted to you, or a change to the law that affects the legality of that application. So the ability of a board to reject these repetitive applications for zoning boards is known as the Fisher versus Dover doctrine. This is a case back from 1972, I think. And this was, and I think everyone always assumed, well, it also applies to planning boards. Well, that argument was made in CBDA Development versus Thornton, and the Supreme Court said yes. The Fisher versus Dover doctrine also applies to planning boards, meaning that planning boards can reject applications, these repetitive applications that continue to perpetuate the same flaws. Once those flaws are corrected, whether it's the content of a plan or the meeting the checklist or providing the fees, once those flaws are corrected, then you're obliged to accept it and begin your review of the application. So you've accepted the application. You've opened the public hearing. Maybe you've continued the public hearing to another time, but some of your members aren't familiar with the property. This is a good opportunity to do a site walk. Why would you do them? Well, it helps to inform you as board members of what this application is all about. So you might be intimately familiar with a piece of property. And if it's a simple project, you might not need to do a site walk. But if it's a complex one, it's a good idea oftentimes to do a site walk. And if you're going to do this, remember, you're finding the facts. You are the fact finder. So you're developing the facts for the record. And walking the site is a very good way to become more familiar with it, with the property and with the development, how the development is going to lay on the land. But note that site walks, if a quorum of the board is present, it's a meeting. You've got to notice it, and the public has to be allowed to attend. You've got to notice it. You've got to take minutes. You've got to document who was saying what and what the conversation was about the site. It's possible for individual members to go to sites and do their own independent evaluation, and that's okay too. And in fact, most board members might say, I know this site. I've lived in this town for 75,000 years, and I know this site. I'm not going to do a site walk. Besides, I don't want to pick up ticks. But others may say, well, I don't know this site. I'm going to go out and check it out myself. That's fine. You can do that. And in fact, the argument against that might be, well, they're not all seeing the same thing. Well, each individual member brings to the board their own knowledge. And I say that's a good thing. This is why we have multiple members serving on boards, because you each bring a different perspective. You each bring different knowledge. But what if it's not enough? The site walk and the application. Sometimes you're dealing with really complex matters, and it is very helpful to have someone else, an expert from the outside, reviewing the application, especially where there are complex or controversial issues. But I wouldn't say controversial is the sole criterion, but the complexity of the application may call for a third-party review, or if it's really unusual subject matter. So my planning board was dealing with an indoor shooting range. And so we hired an engineering firm that had experience dealing with shooting ranges. And the issues were of sound and lead poisoning. Was really important to the public, and so this expert third-party reviewer engineer worked with the applicant's engineer to come up with a plan that we thought was suitable, and that was particularly helpful because no one on the planning board had real expertise in the design of shooting ranges. There were a number of members who were gun owners and knew what they were doing in handling guns, but the design of a shooting range was a very different matter. Your expert can work with your applicant's expert to develop an improved plan, because even where you have engineering standards, there is leeway, there's room for interpretation. And so your engineer might come up with a different interpretation of the same subject matter, or can provide an alternative review and disagree. And there may be disagreement, and that's where you, the planning board, have to decide, we're going to use our engineer, we're going to use the applicant's engineer, or we're going to find something in the middle. And these differences can also serve as differences or agreements can serve as the basis of your approval or denial. Going back, I said that each board member brings their own perspective, and that's really important. But if you've got an applicant with an engineer presenting information, the engineer is an expert. If you are disagreeing with that expert based solely on your own opinion, that may not be enough to deny an application. And this was the case in Trustees of Dartmouth College versus Hanover, where the Hanover Planning Board was the members were relying on their own opinions, and they had expert subject presentation from Dartmouth College, and they refuted those experts' conclusions and said, yeah, we don't think so because we know better. That's not enough. So you get through all of that, you get to the position where you're ready to make a decision. Motions. Who makes the motion? Well, any seated regular member or an alternate serving in the place of a regular member, chair included, unless your bylaws say, your rules of procedure say, no, the chair can't vote. The chair can make a motion, the chair can second a motion, the chair can vote on motions. But your rules of procedure may have specific rules for the chair. Be observant of those. But generally speaking, in the absence of a prohibition, the chair can do all of those things. The motion should contain the complete action, all of the conditions that you're putting on this application, or any reasons for denial should be included in the motion. A motion requires a second and then deliberation. Is there discussion on this motion? And this is where you're talking about the decision itself, and then vote. Sometimes it's really helpful to have a roll call vote, especially in more difficult, controversial decisions where you have a split in your board where it's not unanimous. You should record in the minutes who voted which way. It's very important, especially for people who are voting against the motion, who are voting in the minority. It's important for them to be able to say, I voted against this because I thought it was a bad idea. With a planning board, this differs from a ZBA. The planning board, it's simply a majority of the quorum present. So with a 7-member board, a quorum is 4. You could have a vote that is 3-1 in favor of a decision, and that would be okay. With a zoning board of adjustment, you've got 5 members. The law says you must have 3 votes. So even if you have a quorum of 3 present, there you have to have all 3 voting the same way. The planning board is not the same. Quorum is 4. You can have a vote of 3-1, and that is a passed motion. But what if the motion fails? And I had originally written this more nays than yays, but that's not actually true. So I changed this to not a majority of yays, because you could have abstentions. A failed motion is simply that. It's just a failed motion. It's not approval to do the opposite of the motion. So a motion to approve that fails is not a denial. You've got to bring up another motion there to approve in some other way or to deny, and then put all those conditions in that motion one way or another. I put here abstentions should be strongly discouraged. And I mean this because you are there as a member to act. If you have, so why would someone abstain? Well, I have a conflict of interest. Then you should not be part of that decision. You should have recused yourself. Or I'm afraid I'm going to make people angry. Too bad. That's not why you're there. You're not there to make friends. You're not there to keep friends. You're there to make decisions. And sometimes that means making really hard decisions that may make you unpopular. I'll be blunt here. Have a backbone. It's very important for the public's trust in the process for you to be resolute and make decisions. Don't abstain. It's not why you're there. I want to close with just a word on the role of the chair. The chair is there to run the meeting, to set the tone, to establish expectations at the outset. Here's how we're going to do this, especially where you're dealing with controversial applications, to establish a pattern of respect and fairness, to control the meeting, particularly where there's controversy or emotions are running high. And above all, be kind to the people who are appearing before you. For a lot of people, it's a very intimidating thing. So be welcoming as the chair, be welcoming to people and treat everyone with respect and kindness. I'm going to stop there and turn it over to Ross.
Thank you, Ben. As I was listening to Ben speak, I had two thoughts. One, how fortunate we are in New Hampshire to have such a well-spoken and knowledgeable person like Ben, who is willing to share his knowledge with all of us. And my second thought was why on earth I agreed to speak after him, because I think now I should have spoken in front of him. But at any rate, that's what we have. So we'll learn that for the next time. Thank you, Ben, and thank you, Stephanie. I can't see my presentation there, and I thought I took control, but Stephanie, if you could put it up, we could go through it. I'm the planning director in Salem. Salem is a larger community. Obviously, Salem is a community that's seen a tremendous amount of development over the years that I've been there. I've counted about 700 major projects, about 12 million square feet of commercial industrial development, and about 4,500 house lots or dwelling units in subdivisions and multifamily projects. So we're on a different scale, obviously, of many of the smaller communities in New Hampshire. But I would say that, having reviewed all that development and having spent many years trying to improve our regulations to deal with all that development, the impacts of all that development, I will say that I think there are some things that all size communities can learn from our experiences, and that's what I wanted to do today. I just wanted to go through a couple of regulations that we have for site plans and subdivisions, and then talk a little bit about our rules of procedure and some things that we've developed over the course of many years and a lot of experience with a lot of development. And I hope they are applicable. And I'm going to do all that in about 15 minutes, so we have time for questions afterwards. So we may go a little bit faster than what I had planned. Go ahead, Stephanie. Let's start in. If you can flip to the next slide.
Are you seeing that, Ross? I have
I
priorities.
am.
Okay.
And because I knew I was speaking after Ben, and I knew that I had to do something to make it a little interesting, I've provided some of my favorite cartoons from The Far Side by Gary Larson, which I'm thinking now if we put those in the presentation, I'm probably going to get sued for infringement of copyright. But at any rate, I think they are funny, and it is kind of funny how many of them apply to planning and development. Okay, next slide, please. So we're not rocket scientists. So I've actually used that line many times at planning board meetings. The next slide, I believe, talks about pre-application review. That's something that we've had in our regulations for many years. Nobody can come in and just drop off an application at the counter or a set of plans at the counter. They all have to make an appointment with me, and now we have a assistant planner, so they've got to meet with us to go over the plans. And what we do at those meetings is we review the checklist basically, and we go through the checklist and make sure they have all the information, make sure that the plan is complete, and the planning board in Salem expects us to do that and then to recommend to them at the public hearing whether or not the plan is complete, and then they vote to accept it. Typically, they're not doing that review themselves. They want us to do that. Another thing that we do quite a bit of in Salem is we use conceptual site plans, and this has been very successful and very popular, and a lot of the applicants appreciate the fact that they do not have to do the full engineering design on a subdivision or a site plan, a commercial project, for example, that they can come in with some less detailed plans and talk to the planning board. It's been very successful. I wanted to show you a couple of examples of them. Next slide, please. This is a slide, and unfortunately can't see it, but this is a conceptual plan. A lot of times they color it up. By the way, pretty colored drawings seem to get approved a lot more than plans that aren't so pretty, especially the color green. Everybody seems to think that has an impact on the boards. This is a plan that actually is a little bit humorous. In the middle of the site, there is a mausoleum, and maybe that's not humorous, but at any rate, there's a mausoleum there, and this was a proposal to put senior housing units around the mausoleum, which some on the board felt was a little bit interesting mix of uses there, the mausoleum and the senior housing. If you could go to the next one, please. This is a plan, again, kind of a conceptual colored up plan. This one was kind of interesting. You can't really see it, but, or maybe you can in the title block. This is the Temple of Witchcraft, which we could do a whole session on religious land uses and what to do if a temple of witchcraft comes into your community. It was not particularly well received by the neighbors, as you can imagine, but this is something that was approved by the planning board. And again, the humorous aspects, usually land use planning and zoning and regulations, pretty dry subject, but here several people every year come into the town hall in Salem and ask for directions to the witch house. And hopefully you know this, but the witch house is not in Salem, New Hampshire. It's in Salem, Massachusetts, which is about 40 miles away. So they made the wrong decision to come to Salem, New Hampshire for the witch house. But interestingly enough, we do now have a temple of witchcraft, but that's typically not what they're coming up to see. So next slide, please. One of the problems that we've dealt with a lot in Salem is enforcement. With all that development, you can imagine that it's very difficult to make sure that what is built on a site actually complies with what the planning board has approved. And you wouldn't think it would be that complicated. And I'm assuming that other communities have the same problem that we have, but many, many times it happens where, and sometimes it's just small changes from the approved plan, but many times there are bigger changes. And well, how do you deal with that? You pursue enforcement? We just don't have time. Most of the time it was just me. And I'm doing all the development reviews and trying to enforce those plans, and it's very difficult. And I'm sure in smaller communities it's very difficult also. But one of the things we've done is require outside inspections of the plans. We use an outside engineering company, not just to review the plans, we do that also, but to inspect to make sure that things were done correctly. That's and even though we have an engineering department in Salem, they just don't have enough time to look at all the development. So these outside inspections have helped quite a bit, and they help us confirm that the construction is in conformance with the approved plans, and we've put that right into our regulation that those are required. Next slide, please. The other thing we do, and I know these are kind of boring, but slides with just text on them, but we require an as-built site plan prior to occupancy. And that as-built site plan has to certify that the applicant has done what they said they were going to do in terms of all sorts of things, utilities, building locations, setbacks, parking spaces, any impacts to wetlands or floodplains, all sorts of things. And we require that they identify discrepancies between the approved plan and the what's actually been built, and that they give us a statement saying that any discrepancies or any changes will not result in damaging conditions, or that the changes will function as the site plan was originally proposed. And so that has been a big help in terms of enforcement, more so probably than anything else we've done. And unfortunately, it took us probably 20 years to figure out that that's what we needed, but it has been a big help. Next slide, please. Again, a comic cartoon relating to enforcement, no dumping in the Grand Canyon. A little bit silly, but next one, please. One of the things I want to talk about was subdivisions and lots, and how do you get subdivisions? How do you accept lots that comply with the regulations, not just the minimum lot size and frontage, but also provide lots that are make sense for new development. And I'm assuming others have had the same problem we've had, but there's been such a demand for house lots in Salem over all the years that I've been here. But so how do we get those subdivisions to provide adequate building sites and satisfactory building sites that relate to the topography? We can put that wording in, but what we've had better luck with was saying that lots should generally be square or rectangular in shape, and that you can't put a irregular shape or an elongation just to provide the necessary square footage. In Salem, our minimum lot sizes are 25,000 square feet, where you have water and sewer in the residential district. But in the rural district, where there is no water and sewer, the minimum lot size is 2 acres. And a lot of times we get very oddly, or we were getting very oddly sized lots, and this regulation has helped. Next slide, please. This is a drawing from a booklet that shows some of the very strange configurations. We didn't, of lots and frontages, and we didn't get anything like this, but this was basically what we were trying to prevent with those regulations. Next one, please. We also require a minimum building envelope, and we say that minimum building envelope has to be a certain size, but it's also got to be a certain configuration, either a rectangle or a circle with certain diameters and dimensions. We also require that side lot lines have to be substantially at right angles or radial to street lines for at least 150 feet back from the front property line. And those things have made a difference. Those regulations have made a difference in some of our lots. Although I will say, applicants who can't meet the requirements do come in with waiver requests, but usually it gets them thinking about what they have to provide for subdivision design. Next slide, please. These are just some examples. If you can run through these are pork chop lots. We don't allow a lot of these because there's a minimum frontage requirement, but in certain places, in certain subdivisions, we have allowed these. The bad thing here is that you've got a house on the lots that are in white, and then you have houses basically behind those lots, but the people don't seem to mind that, and they do plantings or fences, and we don't do too much of that in Salem. Next one, please. I always like to use this cartoon when people are talking about cramming in lots. We also require that new subdivisions in the rural district maintain a wooded buffer strip of at least 50 feet wide in front of the lots other than the driveways. And that seems to have helped in a lot of places. A lot of times the developers or the builders are just cutting down every tree in front of the lot, and you lose a lot of the rural character. And we don't have a lot of rural character left in Salem, but where we do, we'd like to try to preserve it. We also say that if your subdivision goes through an open field or a yard, that we want you to plant street trees. Those would not normally not be required in subdivisions, and that sometimes doesn't help right away, but it's going to help over time as the trees grow larger. Go ahead, next slide, please. This is a recently constructed house in Salem. It was a fully wooded lot. We had some rural character on this road. We don't have any rural character anymore. It happened to be in the residential district, so they didn't have to provide that 50-foot buffer. Next one, please. This is just an example where if you can get even a row of trees in front of the house lot, you can make it look a little bit different than it would otherwise look. Of course, when the leaves are off the trees, it's not as effective, but it is effective for some months of the year. Stephanie, I see that I'm over my time. If you could just slip forward to the rules of procedure, I'll just talk about those for a little bit, and then we'll have more time for questions. On my computer, it's going slowly, so I wanted to talk about our rules of procedure a little bit. We talk about ethical standards. I was thinking about this the other day. It's kind of interesting. We've still had all sorts of problems, but at least the standards are in our regulations. We say that you should be disqualified. You should step down if there's, for any reason, you are disqualified to act as a juror, and the juror standard is a tough standard, and it's written in state law, and we specifically refer to that and spell out those standards, because a lot of times it's not clear when somebody has to step down. We also say your primary obligation is to serve the public interest. I'm sorry for the layout problems here, but serve the public interest, conduct themselves as to maintain public confidence in the planning board. We had a problem with a court case one time. Somebody stepped off a presentation and spoke to one of the planning board members and thought they heard something really wasn't quite accurate. But at any rate, our lawyers have said to us, there shouldn't be any discussions between planning board members and applicants or their agents other than at a public hearing and something that's on the public record. Now try enforcing that with your planning board members or other members who know people in the community and know the surveyors and engineers that do work. And it's not easy, but at least it's there in writing. We also added a clause, and you can maybe figure out why we added the clause. ZBA members who have legal or other problems should step down until those problems are resolved. That was basically because of a problem with a member on the ZBA who was, his name was splashed on the newspaper, and people thought that reflected poorly on the zoning board. What else do we have here? One of our things for agenda management, and we put right in our rules of procedure, is that we allow applicants to come in without all their staff approvals, without all the issues resolved. We come in for a first meeting, but we say when you come back for a second meeting, let's have everything resolved at least a week in advance before you come in for your final approval. And the reason we did this was because we had applicants coming back 5 or 6 or 7 times, and they'd never get everything resolved, and we'd be spending all this time in meetings. We'd talk and talk and talk, and it was never ready to be approved. So we said, and we've been pretty successful in this, saying to people, hey, don't come back for the second meeting. Come in for the first meeting. Let's talk about it. Let's hear from the abutters, but don't come back until most everything has been resolved. And if you do have something you have to talk about with the planning board, fine, we can talk about that, but try to get all the approvals from everybody. This I thought related to ethics, this cartoon. And the last one I think is what I hope you all, how you all leave your communities. Hopefully you sure cleaned up your town. I hope they say that about me. Thank you very much.
Fantastic. Thank you, Ross. Wonderful presentation. It's always great to have someone with your expertise exposed to many different situations, and Ben as well, to help out the boards with and without staff. It's all very much appreciated. So we do have a few questions. Let's check in with Katie to see if we have anyone on the phone that's been waiting patiently for a question. Katie, is there anybody on the phone?
We have nobody on the phone. We do have a couple people with their hands raised. So I would just ask, for the sake of time, if your hand is raised, if you don't mind typing it in the chat, if you haven't already, just to efficient with the next 8 minutes that we have. So
sure. Okay. So yes, we do have a few questions that have been stacking in the chat right now. So let me get my act together here to get to the first question we had. Can site plan regulations apply to residences, or is it strictly allowed for commercial multi-unit housing?
It sounds like a legal question. Go ahead, Ben.
So the site plan regulation enabling statute is pretty clear on this. Site plan regulations apply only to non-residential or to multifamily, which the statute defines as 3 or more dwelling units in a structure. So site plan regulations cannot legally apply to single family dwellings or to duplexes.
Okay, thank you.
And we say that right in our regulations under the applicability of site plan regulations, what it applies to, and it wouldn't include single family homes.
Okay, we'll give this next question to Ross. Does a commission need rules of order? Thinking of a broadband commission. Do commissions need rules of procedure, rules of order?
I don't know why we can't give that one to Ben, but in terms of commission, we have various committees, and they typically don't have rules of procedure. They might have a charge or a kind of a charter from whichever group has set up the committee, but we would typically not have rules of procedure for or rules of order, I think they mentioned, for anything other than planning, zoning, conservation.
Would Ben concur with that?
I do.
Okay.
The statute people should look at is RSA 676:1, and that says that local land use boards should have rules of procedure. Other statutes may deal with other boards, but we're talking about here planning boards and other land use boards.
Okay. So the planning board is the gatekeeper of subdivision and site plan regulations. Are they obligated to adopt changes when they are approved by town vote on a warrant article?
Well, the only thing that the town vote would be, and again, Ben knows more about this than I do, but a vote at a town meeting would relate to the zoning regulations, not subdivision and site plan regulations. I don't believe that those, I know those are adopted based on a vote of the planning board, but any zoning changes would be binding on the planning board and on the zoning board.
Okay. What is included under building development in the list after sale, rent, and etc.? So I'm wondering if that's in relation to the subdivision, what the definition of a subdivision is. If Bonnie is still online, if there's a way that you could maybe throw something in the chat for clarification for that question to make sure that we answer it correctly. And just, she had another little follow-up question here until we get clarification on her first one. Can you make an applicant comply with changes in the law after the application is accepted as complete?
I'd say no. We've had that several times where we've had applicants submit plans, but we've got zoning amendments that are pending or changes in regulations that are pending. And we have always been advised legally that once we've accepted the plan, that locks in the rules that were in place when they submitted the plan, and that we cannot apply new rules to those plans that have already been accepted.
Yeah, I agree with what Ross has said there, and I think that principle of vesting applies as soon as an applicant submits an application that is sufficiently complete for the board to accept. Once that's in the hands of the town, then the law around that is essentially fixed. And there are two statutes people should look at. One is RSA 676:12, which deals with issuances of building permits, but also RSA 674:39, which is the 5-year, I forget exactly what it's called, but it's a 5-year vesting period. And there's that essentially says that changes to the law don't apply except for things that deal with public health and impact fees. So a change to impact fees potentially can apply to an application that is pending or that has been approved.
Okay. For clarification, Ben, if you abstain, is that considered a positive vote?
No, it's not. I see the point that someone made, I forget who,
If you,
about it, an abstention going to the majority, and that's potentially true, but if you have a number of people abstaining, then you essentially don't have a majority voting for something. You have to have a majority of the quorum voting in favor of a motion for that motion to pass.
Okay, yeah, I was going to answer that. There's another little abstention question there. Thank you, Ben. Does Salem have contiguous area requirements, say a stream that runs through the middle of the lot?
Yes, we have a minimum area, contiguous area for the creation of new lots. It's not particularly onerous. It's 20 or 30,000 square feet, so something like that. But yes.
Okay, thank you. Should a town have administrative rules allowing the town planner to approve certain additions and changes without coming back to the planning board?
I think that's a great question. And I'd just like to say that in Salem, we always had kind of an informal policy where if you had a smaller project, not a new building, but say you were going to put an addition on, or maybe add some parking or do some other things, it was always an informal policy. You could submit a letter and a little sketch plan, and I'd bring it to the planning board and see whether they wanted to see a full site plan or not. And we incorporated that into our site plan regulations. We spelled out some criteria. We said, if you're going to only put an addition of less than 500 square feet, if you're going to change the landscaping, if you're going to change your sign, or if you certain criteria within certain limits, you can write a letter, give us a sketch, bring it to the planning board. We don't notify butters, and we ask the planning board if they have any concerns. And most of the time, they have no concerns. Those projects are able to go forward. Every now and then they'll want to see something formally, but pretty rare.
Yeah, I agree. It is a pretty good process for streamlining. It does help for minor changes. Ross, you talked about as-built. When I was town planner, I loved the as-built because you can go ahead and allow someone to make changes, continue moving forward with the project, and then catch up later, so to speak, with an as-built. I found it easier for the applicant, for time and money, and the board and staff. So thank you very much. We're wrapping up here right at 10:31, so we're a minute over. But if anyone's didn't get a chance to put their questions into the chat, our speakers have graciously agreed to answer any questions relating to this presentation. Their contact information is in the slides. And again, I just want to can't thank enough Ben and Ross for being here. Your expertise, your teaching styles, your candor, your longevity. You truly are planning gems in the state, and we appreciate your time and your volunteering for us today. So, and we're hoping for your continued longevity here. So we will wrap that up. And again, thank you very much for joining us. We're going to do a 10-minute break, and then we'll be right back at it with the planner. The planner is in. So thank you very much, everyone.